Ladies and gentlemen, good afternoon. Thank you for joining us again after this very nice lunch here in Brussels. I'm Bojana Bellamy. I'm not the commissioner, but I've got a great pleasure, and not yet, a great pleasure and privilege to introduce our new commissioner, Michael McGrath, who is the Commissioner for Justice, Rule of Law, Consumer Protection, and has got a very short time with us today. But we are delighted to welcome him because he's looking after so many things that we all care about in this room. He's looking after the GDPR implementation and proper enforcement. He's looking after also questions of potential simplification of GDPR to make sure that this law continues to provide the foundation for the pro-growth, pro-innovation agenda that we all need in Europe. He's also got some interesting things like GDPR procedural regulation, for those of you who are following that as well, but also things like data flows, right, under his umbrella. He was in Washington. We all read quite a lot about his discussions there with the FTC chair and a number of politicians and thinkers in Washington. And then finally, he's going to be looking after the new agenda of Digital Fairness Act, which again may have some impact on data privacy. So Commissioner, with that, please, we welcome you to address our group of privacy leaders, professionals and regulators. Thank you very much.
Well, thank you very much, Bojana, and thank you all for the warm welcome here this afternoon. It's a great pleasure to be here with you all, and I look forward to delivering some remarks on what is an incredibly important topic. I also want to acknowledge the MEPs who are here this afternoon as well, and to thank them for their attendance. I have an engagement at the Parliament immediately after this, so that is why I do need to go afterwards. But it is a great pleasure to join you at the 14th Data Protection and Privacy Conference to talk, of course, about data protection, the GDPR, and its relationship with the expanding body of EU digital legislation. This is my first data protection and privacy conference, certainly not the last, hopefully the first of many over the coming years. Over the past 5 years, I think it's fair to say that we have witnessed the transformative nature of the GDPR. As we reflect on where we stand today, it is important that we look ahead and that we consider the future of data protection. Last summer, we published our second Commission report on the GDPR, identifying both successes and also areas where improvement is required. The good news is that the GDPR overall is working effectively. People feel their rights are protected and that they are actively exercising them. Data controllers and processors appreciate the GDPR's risk-based, technology-neutral approach. It's clear that the regulation is a vital element in building trust in the digital economy, and that trust in many ways is the foundation on which the full potential of the digital economy can be achieved over the period ahead. However, despite this success, the report also identified areas where more can be done to fully realise the enormous potential that GDPR has. Our key takeaway is the need for greater support to businesses, especially SMEs, in their compliance efforts. And to address this, the Commission has called on national data protection authorities and the European Data Protection Board to provide more tailor-made guidance and tools to assist them. This will help to alleviate any unfounded compliance concerns, especially for organisations where processing personal data is not their core business, and many of them do not necessarily feel they have the knowledge or the tools to ensure they are fully compliant, and the vast majority of them do want to be compliant. These guidelines should first and foremost be easy to understand for individuals without legal training, and they should be based on early consultations to ensure maximum clarity. In addition to that, the Commission will present a proposal in the coming weeks to simplify the record-keeping obligation under the GDPR for small operators. This was announced in the Competitiveness Compass for the EU presented earlier this year by the Commission. In addition, as announced in the political guidelines for the current Commission, we will put forward a European Data Union strategy. This will aim to ensure a simplified, clear and indeed a coherent legal framework for businesses and administrations to share data seamlessly and at scale while respecting high privacy and security standards. Beyond supporting small operators, our GDPR report calls for national data protection authorities and the European Data Protection Board to ensure more consistent interpretation and enforcement of the GDPR. Consistency by all regulators across the Union is essential to avoid and prevent legal uncertainty for individuals and businesses. And I do think that much of the criticism that is levelled at GDPR actually relates to the often lack of consistency around the interpretation of GDPR and indeed the application of it. And I think if we can make improvements in that space, it will go a long way to addressing the concerns that some have expressed in relation to the GDPR. In 2023, the Commission took action to strengthen enforcement of the GDPR with a proposal for a regulation on GDPR procedural rules to facilitate enforcement cooperation between the national data protection authorities on cross-border cases, and so many cases are inherently cross-border in nature that this cooperation on enforcement issues is absolutely fundamental. This proposal is a response to requests, especially from data protection authorities, to address problems stemming from conflicting national procedural rules. The goal is to harmonise certain procedural aspects to achieve greater consistency and less fragmentation in the implementation of the GDPR across our Union. We are hoping for a swift and balanced agreement of the co-legislators on this important file. Our report from last year also underscores the GDPR's role as a cornerstone of EU digital policies. It helps businesses and individuals to harness the benefits of the digital transition while fully respecting the right to data protection. And that is the balance that we must achieve. Take the European Health Data Space Regulation, the EHDS, for example, the first of its kind. It builds on the GDPR and provides robust conditions and privacy safeguards to allow the reuse of personal health data for predefined societal benefits. The EHDS is therefore an enabler of AI innovation in healthcare that is compliant with the GDPR. Speaking of AI, another piece of groundbreaking legislation building on the GDPR is the AI Act. This provides for one set of rules for businesses to access and operate in the EU market. It ensures that consumers will have the guarantee that AI developed and used in the EU respects their fundamental rights, and the Charter of Fundamental Rights in every respect must always be complied with. However, our new digital regulations touch on issues falling within the domain of several regulators. We must break the silos to foster efficient cooperation across regulatory fields and ensure the coherent and effective enforcement of the EU's digital rulebook. In summary, our main priorities are clear. We should focus on harmonised implementation and enforcement and build synergies and consistency with the EU's digital rulebook. The Commission will continue to strive for innovation while preserving the right to data protection, and we are committed to cutting red tape and reducing administrative burdens, especially for SMEs. This is at the heart of the Commission's mandate, the political guidelines, and it's reflected in the mission letters that commissioners have been given by President von der Leyen. I want to turn now to the critical issue of law enforcement access for personal data in our digital age. At the Informal Justice and Home Affairs Council organised by the Swedish Presidency in 2023, a discussion on the fight against organised crime in the digital era highlighted a growing challenge. Criminals are going dark through encryption-protected communications, making it increasingly difficult for our law enforcement agencies to detect and then to intercept them. In response to this growing trend, the Commission and the Council set up a high-level group on access to data for effective law enforcement. And in November last year, this group published a report summarising 42 different recommendations covering issues such as capacity building, cooperation with industry, standardisation, and possible legislative measures. They focused on 3 specific areas: digital forensics, data retention, and lawful interception. They want better or more tools in those areas to pull more criminals out of the darkness. Balancing the need for public security and safety with the protection of fundamental privacy and data protection rights alongside cybersecurity goals requires an evidence-based exercise. And in the early months of my time in this role, I have met with the various bodies who are involved in the justice field, Europol, EPO, Eurojust, just to name a number of them. And many of them do raise issues around data retention and access to data for law enforcement. And they would broadly be of the view that there are areas where improvements are needed. I think we have to acknowledge their concerns and examine, in the context of the recommendations that have been made, whether further steps need to be taken in that regard. Ensuring innovation and privacy rules coexist without undermining the other is no small task. But with effective cooperation, enforcement, and an underlying commitment to fairness, I do believe that we can achieve it. Looking ahead, I want to reaffirm my commitment to making sure that the GDPR continues to respond to both law enforcement and commercial needs. I want to thank you for your attention to my remarks here this afternoon, and I want to thank you all for coming together, because this is a very important event. It is critical that stakeholders engage with each other, understand the different perspectives, share concerns, share experiences, but also share best practice, so that we can ensure that our GDPR regime within the European Union is fully fit for purpose, and that it is consistent with all of the other objectives that we have in our union, including improving the competitiveness of the European economy, which is a fundamental objective that we all share in the current mandate of this new Commission. So thank you for your attention, and I wish you a successful remainder of the conference. Thank you very much.